What's up, party people? It's your favorite neighborhood lawyer, Markwell Cade with Cade Mark Law, back with another resource for you. I have a lot of clients hitting me up after the first of the year looking to get wills done. And every state has differing laws on wills, but almost every state requires for there to be at least 2 witnesses to a will in order for it to be valid. We're going to talk about 3 requirements today for those witnesses to your will. Now remember, this is only a general guide because each state, as I mentioned, is going to have its own laws on wills and witnesses to the will and what the will must require and all of those things. But generally speaking, these are 3 things that you will want to make sure you check off when you're looking for witnesses to your will. The first requirement that most states have for witnesses to a will is that the witness must be an adult. They must be 18 years or older to be a witness to a will. This means that your children, your smaller cousins or smaller nephews and nieces, or other family members or friends that aren't adults can't be a witness to your will. You must find someone who's 18 years or older. The second rule or requirement is that generally speaking, the witness must be a disinterested party. A disinterested party is simply a fancy way of saying a party who's not getting anything in the will. This means that you can't use witnesses that are beneficiaries or people who will be gaining something from the will you're creating. A witness must be someone who's impartial, someone who has nothing to gain from being a witness to the will. This requirement generally prohibits spouses or relatives or other beneficiaries from being named as witnesses to the will. And the reason for this law is to prevent a conflict of interest in which a court could disinherit that party because they gained something from the will and were a witness. So to prevent any issues down the road, you want to make sure your witnesses are disinterested parties, not your spouse, not your relatives, not anyone who stands to gain anything from the execution of your will. The last requirement is definitely state specific, as some states allow this to occur and some states don't. But generally speaking, your witness must not be your executor. Executors don't always gain something from the will. They're not always beneficiaries, but the executor is the person who's in charge after you're gone. The person who's in charge after you're gone can't also be a witness to the will signing in some states. In others, this isn't a problem. Check with your state or consult with a lawyer in your state on the requirements on whether your executor or the person you name to be in charge of your state can also be a witness. But generally speaking, your executor and your witness should be 2 separate people. Bonus tip: choose witnesses that you know will be available in the event that you pass away and your will needs to be probated. You want these witnesses to be able to come to court and testify. Make sure that they can be there in the event you're gone. If they can't, there is a chance that a court or that your will is contested and a court can't hold it valid because the witnesses who signed aren't there to testify and verify that you were the one who actually created this will. That's what your witnesses are for. That's all, folks. Thank you so much for joining us today. This has been 3 general requirements for a witness on a will. Once again, I am Markwell Cade with Cade Mark Law, your favorite neighborhood lawyers. Protect your brand, grow your business. Stay frosty, my friends. We will see you next time. We hope this was helpful.